Welcome to Legal Guidelines Prep for Florida law enforcement officers. This is Deputy Z, and today I will be covering probable cause, which will include probable cause with regards to probable cause guidelines, when to release a subject after PC evaporates, proper identification, the fellow officer rule, and other bases of probable cause. As always, nothing stated in these videos should be taken as legal advice and should only be used for educational purposes. An arrest by a police officer pursuant to a warrant or warrant exception must always be based on probable cause. The officer must have probable cause to believe that a particular statute has been violated by the subject and that all the elements enumerated in the statute are present. In Florida, probable cause for an arrest exists when the facts and circumstances within an officer's knowledge is sufficient to warrant a reasonable person in the belief that an offense has been or is being committed. See Jenkins v. State. The determination of probable cause for an arrest is a layered concept wherein the officer must use all the factors and circumstances available to him at the time, also known as the totality of circumstances. Probable cause to make an arrest is a lesser standard than the required for the conviction, which is proof beyond a reasonable doubt. The only factors which will be reviewed to determine whether an officer had probable cause for an arrest are those factors known to the officer pre-arrest. Pre-arrest factors establishing probable cause may include the officer's observations, as well as those of fellow officers, information received from citizens, such as witnesses, informants, victims, etc., and physical evidence. The pre-arrest factors establishing probable cause are the most important because these factors must establish probable cause prior to making the formal arrest. While post-arrest factors may be used in the subsequent determination of proof beyond a reasonable doubt, probable cause for the initial arrest must exist in the time of the arrest. Now for PC guidelines. Once an officer has determined that probable cause exists and an arrest has been made, it is equally important that the documentation of the incident and circumstances be as complete and accurate as possible. The initial evaluation of whether probable cause for the arrest exists will be made by a judge or an assistant state attorney based on a review of the arrest affidavit. Therefore, it is critical that this document contain all the necessary elements to establish probable cause. Officers should document all facts and evidence that will lead the reviewer to the conclusion that probable cause exists for the arrest. Facts supporting all elements of the charged offense should be covered. Avoid using broad accusatory statements. It is also encouraged for officers to provide details as to how and or why the officer encountered the subject in the first place. A detailed arrest affidavit and accompanying police report may also serve to refresh an officer's memory if court proceedings take place after an extended period of time. There can be serious consequences for both the officer and the department if it is determined that there was no probable cause for an arrest. Charges against the defendant will be dismissed, evidence may be suppressed, the officer and department may be targeted for civil lawsuits, and the officer may face criminal charges. Now, release of an arrestee. During the course of an investigation, information may come to light subsequent to the arrest that affects the probable cause determination. Probable cause to believe that the defendant committed the crime may evaporate in light of new information uncovered in the subsequent investigation. This may occur shortly after the arrest or after an extended period of time. Upon making a determination that probable cause for an arrest no longer exists, which depending on the circumstances may require consultation with the prosecutor or in-house counsel, the arrestee should be immediately released. The officer should make every effort to return the individual to his or her pre-arrest state by transporting the arrestee to the original place of detention, releasing all personal property impounded, etc. Accordingly, the arrestee should be given an explanation regarding the circumstances relating to his or her release. Caution should be exercised in the release of information if the investigation is continuing, so as not to divulge any criminal investigation information. Individuals should be assisted in recovering their vehicle if one has been towed and given any other reasonable assistance. The subsequent release of an arrestee based on new information which negates probable cause does not mean that the original arrest was without probable cause or was illegal. The initial arrest still retains its legal validity based on the facts known to the officer at the time of the arrest. In all such cases, a detailed report must be prepared containing all pertinent information. Identification required for probable cause. An officer must be sure that the description of a suspect is sufficiently detailed before he or she can effectuate arrest. If the description is too vague or general, the officer should refrain from making the mistake of arresting the suspect prematurely. Instead, he or she should ask the suspect certain questions or keep the suspect under surveillance. Obviously, if those procedures are not practical, the officer should use common sense and take reasonable steps to keep the suspect under observation. Law enforcement officers can obtain information from a variety of sources, which will constitute probable cause to arrest. The most obvious sources are personal observation of the victim of a crime, who can usually supply the most relevant details. The victim is the best source because courts will assume that he or she is reliable and that he or she obviously knows what he or she is talking about. Unless a police officer has reason not to believe a victim, for example, if he or she exhibits emotional or mental problems, for example, the officer can rely on the victim for sufficient probable cause to make an arrest without having to verify the information. A police officer can also rely on a citizen who is not the victim of crime to provide information which will constitute probable cause. While the courts have also found this type of citizen to be trustworthy, an officer must still verify that the citizen knows what he or she is talking about. This is known as a citizen's basis of knowledge. Occasionally, a victim will tell a police officer that he or she is not 100% certain of identification, or that a person only looks like the perpetrator of the crime. This information is usually insufficient to provide an officer with probable cause. However, probable cause will exist if the victim picks out a suspect's photograph. The fellow officer rule. If a law enforcement officer has information amounting to probable cause, he or she can communicate the probable cause to an officer who lacks that knowledge for purposes of a second officer making an arrest. The directing officer's knowledge is imputed to the arresting officer. See State v. Bowers. This rule is applicable whether the communication is from a superior or fellow officer or between officers of different agencies. See Smith v. State. The fellow officer rule pertains to misdemeanor offenses as well as felony offenses. Be aware that the fellow officer rule applies in cases of searches as well as arrests. See State v. Peterson. However, the fellow officer rule does not allow an officer who does not have first-hand knowledge of the traffic stop and was not involved in the investigation at the time to testify as to hearsay regarding what the initial officer who conducted the stop told him or her for the purpose of proving a violation of the traffic law so as to establish the validity of the initial stop. And finally, other bases for probable cause. When a police officer relies on information from fellow police officers or from official police sources, he or she is entitled to assume that the sending officer has probable cause and that the information is reliable and accurate. However, an officer should also realize that if he or she acts on information which has become stale or outdated before the arrest, for example, an outdated arrest warrant, parole warrant, stolen car report, etc., the arrest will be voided by the courts. Note also that a failure to make a diligent search when acting on a warrant can invalidate arrest. The court in McNeil v. State held that the delay in serving a capias for a defendant in a non-capital, non-life felony, grand theft, may be determined in light of the defendant's effort to elude arrest, but where the state offered no evidence of a diligent effort to locate the defendant. Probable cause can come from a variety of sources. A police officer can obtain information from a defendant's accomplice, an officer can utilize fingerprints at the scene of a crime, or even information from a conversation heard through a wall to obtain the necessary information for an arrest. It is important to remember that the courts will review the information underlying the arrest, whether or not there is probable cause, from an objective view. Probable cause does not require officers to rule out a suspect's innocent explanation for suspicious facts. The relevant inquiry is not whether particular conduct is innocent or guilty, but the degree of suspicion that attaches to particular types of non-criminal acts. In Curtis v. State, an officer was on routine patrol. He approached the defendant and another individual because he wanted to get to know the people in the area. While speaking with the defendant, standing about 2 feet away, the officer observed what he identified as a rock of crack cocaine in the defendant's mouth, partially concealed by his upper lip. The officer had 5 years of experience, during which time he had made hundreds of arrests for crack, and he knew the upper lip was a common hiding place among users. The officer had probable cause to arrest the defendant and could order him to spit the crack out as part of a search incident to arrest. But see Johnson v. State, where the discovery of crack cocaine in a cigarette pack lying on the ground about 1 foot from the defendant did not establish probable cause for the defendant's arrest because no evidence presented that he or she was ever in possession of a pack of claimed ownership of it. And that concludes probable cause.